Supplementary. Item number 1.
Supplementary. Okay, thanks. What is this? Oh, where's the petitioner?
Petitioner is on sanction leave as per the cause list, Your Lordship.
Oh. No mention on behalf of sir.
No mention. No.
So what should we reject the appeal?
I leave it to Your Lordship.
Yes. Anyway, as the counsel for the appellant is on sanction leave, this is matter for 2 weeks.
Item number 2.
In this case, there is a delay of 23 days, my lord.
23 days.
Preferring the appeal.
Who's the accepting notice?
Yes, Lordship.
Do you have any objection to the condemnation application? What's the matter about?
This is regarding the appellant who was serving at Nigrim's, my lord, as a technical assistant, and then thereafter, my lord, he was released from service.
In Nigrim's?
In Nigrim's.
Then what happened?
My lord, what has happened is in between they have issued a letter saying that the post of technical assistant will be filled up by outsourcing, my lord, and that was challenged, my lord, before this honorable court by the WPC, my lord. 253, my lord. And then in that case, my lord, the honorable court has asked me to file a representation before the court, because I have also come before the court, representation before the Nigrim's authority, my lord,
yes.
Because I have also prayed for regularization of my service in that case. And then when I filed that representation, my lord,
he's still serving in Nigrim's now also.
My lord, he has been released from service. That is under challenge, my lord, in the previous repetition, my lord. That is WPC 424, my lord.
Yes.
And that order was under challenge. In the meantime, my lord, what has happened is the Nigrim's has filed an affidavit saying that the post has been deemed abolished, whereas it was found that a person, he is already working under outsourcing process, my lord.
So outsourcing,
outsourcing method he was appointed, my lord, and that is under challenge.
Outsource, that specific post has been outsourced, you mean?
Outsourced, my lord. That technical assistant, my lord, there is a law.
Filing appeal, if that other cause has died, then it will be a fresh cause of action.
My lord,
why are you filing a writ appeal against the early order? What does the order say?
In the
order, I agree with the order.
My lord, my contention is that, my lord, my grievance was that the post of technical assistant, my lord, it cannot be filled by way of outsourcing method, my lord.
No, in this writ appeal. In your writ petition that you already said 253, correct?
Yes.
What was the challenge there?
253, my lord. Thereafter, I had withdrawn that case. I went to the authority by way of representation.
Then you filed a fresh writ petition.
I already filed, my lord, the fresh representation, that is 424, my lord.
Petition.
Writ petition, my lord.
You filed a fresh petition also. It's pending.
424, my lord, I have filed. That was disposed, my lord. That order is under challenge here. That is page number 96, my lord.
Yes, what's the operative parties are needed out?
Page number 96.
Yes.
Order dated 15/9/2023.
Yes, what is it?
When that writ petition was pending, my lord, and then Nigrim's has filed an affidavit stating that the post, my lord, of technical assistant has been deemed abolished.
Your prayer that means some substance before the division bench just for reopening the matter and remanding it back to the single bench for rehearing? What do you want?
My lord,
because the thing is that nothing was decided, that means in your writ petition.
Now,
apart from the fact that that it was closed since they have made a submission that post no longer exists. That's it, correct?
That is what, my lord, their submission. My lord, in fact, the truth is, my lord, the post is not abolished, my lord. Post still exists, my lord. That is my submission, because they have given a wrong submission, my lord, before the learned
Dr. Mojika, is that correct? What was the his grievance in the petition, how is it addressed? Did the order go into merits at all? Does the post exist? And whether the writ appeal is maintainable or not? If you do not agree with that order, then what do you become writ appeal for?
That is what, because that petition, my lord, WPC 424, my lord.
Yes.
That was disposed only on the averment that the post has been abolished.
So you want a 424 to be reopened now?
No, my lord.
Then?
I want this order to go because this order was passed, my lord, on the basis of the affidavit filed by the Negrims, my lord, wherein they have said that the post has already been abolished. Whereas it is found that the post still exists, my lord.
I don't know what relief you'll get anyway. Yes, Dr. Boy, anything to say?
My lord, today is for condonation of delay. Also,
You have no objection, 23 days, nothing.
but here what happened, my lord, he was appointed on contract basis, my lord. Then in terms of the policy, because in central government mostly they are appointing now through outsourcing method. So his post was converted into outsourcing. In the meantime, advertisement was issued, my lord, for filling up many posts, including this particular post, my lord. Now, what happened, my lord, because during the pendency, because there is a policy of deemed abolition of posts, my lord, in the central government. If any particular post is not filled up for 2 years, then there is a deemed abolition. So, Negrims is taking up steps with the central government, my lord, to revive those posts. And that was the submission in our affidavit filed before the learned single judge. And with the condition that if the posts are revived, my lord, and advertisement is proceeded with, he will be able to apply for that, my lord.
That's not a submission. A submission, he says that you had made a pointed submission before the single bench that the post no longer exists and he's been relieved from his services.
My lord,
and now again the same post he outsourced it to someone else.
But the regular post does not exist, my lord, because it has been deemed abolished, my lord.
Anyway, we'll... Miss Case 52-2023 in writ appeal number so and so. Yes, this is an application for condonation of delay of 23 days in preferring the instant writ appeal. Stop, Dr. Nekparaga, Dr. N. Mozika has entered appearance on behalf of all the respondents. No further notice is required. Stop. Further, the learned DSG for submits it. He has no objection to the condonation application. Stop. Accordingly, the delay of 23 days stands condoned and the Miss Case is disposed of. So, registry to register and diarize the writ appeal. Stop. The made writ appeal. Heard Ms. N. Singh Conlon and counsel for the petitioner. Stop. For the appellant. Stop. As also Dr. N. Mozika. This is matter for further consideration. When you want for admission?
After 3 weeks, madam.
For further consideration. For admission hearing, this is the matter for admission hearing after 3 weeks and so and so. Yes. Otherwise, you have who's to end up sitting in advisory capacity.
Main list, item number 1.
Please. What is this, Mr.
This matter relates to traffic matter.
Yes, Mr. RK General.
We filed the latest report, Lord.
When was the report filed?
Yesterday, Lord.
Yesterday?
This is detailed report, Lord.
But that we report what I was submitting, my lord,
Yes.
Lord. But we have been taking steps to just the traffic scenario, my lord, and we have consulted IM Shillong, we have consulted Delburg, we have consulted, and we have taken a number of steps. As per your lordship's last order, the petitioner was required to come back with the views on our report, my lord. What I was saying, my lord, this is a perennial problem which will continue and we will keep addressing this issue. What I was praying that in the light of various status reports, your lordship may consider disposing of the matter.
No. Mr. RK General, the one incident that happened recently, which has really, alarmed the citizens and even the court regard to what happened to the fire there in Police Bazaar.
Yes,
Where because of the congestion and the vendors, that even the fire tenders cannot reach on time, which leads to loss of life. And that we cannot have the situation. Whatever it is, whatever one notwithstanding the scheme, whatever you're putting, the rule of law should be upheld. That's the thing. Now there has to be a balance between the citizens. Citizens should be a balance between the people who have a right to use the roads, the traffic and everything. It's like
what I was thinking is fire that can be taken up as a separate issue, because this is issue which is coming up again and again in Shillong, Lordship has seen earlier also, last year also, street building and all, Lord. So that.
Have you furnished copies to the?
Well, I have received the copy this morning, my lord. May I submit? For the last, my lord, 2 years, the government is submitting report one after another, and the steps, my lord, is not visible. And here in the report, this report also, they say they have formed the Shillong Decongestion Committee, my lord. Now, may I suggest with lordship permission, the committee members are only from the government department, and it seems, my lord, para one of that report, para
Where
one,
does it say?
para A, it says
Collaborative.
cooperative to facilitate, coordinate, and monitor the efforts taken by the various departments to resolve the traffic congestion. The state has constituted the Shillong Decongestion Committee under the chairmanship of the Chief Secretary. The committee comprises of multiple stakeholders from the government, including Home, Police Department, Office of Deputy Commissioner.
So what do you want?
SP.
You want that
Now,
from
here,
the
my lord,
other stakeholders? And
my lord, if lordship permits, may I suggest that other independent person who is well equipped with the town planning system, that would be a great feedback to this committee. This committee, my lord. Otherwise, my lord, they are filing one up the report one after
yes,
another.
okay, General.
Your lordship, allow me that one.
We have already, this is one of the committee at apex level, Lord. We have already in touch with district council, Darbar Shillong, Lord. We have been conducting and meeting them time to time. Various meetings are being conducted. So this is an official committee, Lord, where the officials will be taking.
Okay, suppose there's no harm having an independent member. Who do you have in mind? Yourself.
If lordship allow me to suggest, my lord, method makeup after 1 week, I have tried to suggest my lord, the reliable.
No,
the
we'll
local.
appoint one of you to sit in that committee from the court.
My lord,
One of the lawyers. What do you say? Instead of you're not going to have a person who has a slanted interest sitting in the committee. We have someone who can, who's fair and above board.
my lord,
What do you say, Mr. Khan?
Lordship is correct. Absolutely.
Let an independent member sit.
Absolutely. Independent member.
One independent member sit.
my lord, may I suggest senior counsel
Yourself.
Mr. Themis Tingdo and other, my lord, other person who has
He is too busy.
who know the local situations, my lord.
Yes.
And my lord, other members also there who is well equipped with the town planning system.
This is probably fine with us. Now, let's see the last order. My brother has pointed the last order of this court. What does it say?
Last order is, Lord.
1810.
Lordship. The
Yes.
Lordship says, my Lord, that petitioner respondent number 16 should go through the report and point out deficiencies and anomalies. Paragraph 4.
My
So,
lord,
does this report contain out of the box solutions?
Traffic is a problem which is perennial to all over world, including India.
pursuant to the last order, my lord, we are preparing to point out the genuine shortcomings, my lord. Within a week's time, we will find. For the last 2 years, my lord,
You will have this matter on Monday.
Monday, and if lordship allow me to suggest at
You
least
can
2
do
names.
something. Yes, suggest names.
Subject
Otherwise,
to
the
lordship.
court suggests by itself. Let one independent member sit in that committee.
Yes.
Yes.
We will place the complete the composition of the condition committee, my Lord. It is a short form so that your Lordship will have.
Yes, I mean, at least you co-op one member from, not from civil society, one lawyer. Yes.
But I will place the entire committee before your Lordship. Because
Yes,
it says others also.
You take down pursuant to the order dated.
I'm also.
Yes, Mr. Mata. Sorry. Yes.
What happened, Your Lordship, suggesting Honorable Chief Justice Mohammed Rafiq has passed this order on the traffic as back in 1511 to 2019, Your Lordship. And the government assured that they would comply with this order. It's very unfortunate that from 2019.
See, Mr. Mata, I have 30-40 cars being registered every day.
I know. This way, Your Lordship was pleased to dispose of.
You've been referring to this order for time to time?
Correct. In that case, I appeared in person, Your Lordship. Few suggestions were then coming up things.
What are the total number of cars registered which are applying in Shillong and under ML05 registration? How many, including this?
80% household has.
No, we would like to have a figure. How many cars are there? How many scooters are there? How many bikes are there? And what is the average registration of vehicles every month in Shillong?
Well, with regard to bike accidents, my lord, we obtain the information through
Bike
RTI.
accidents?
My lord, we will bring
How
on
about a
report.
number of registered vehicles which are plying under this East Khasi Transport Authority registered there?
Well, last 3 weeks or so, my lord, in St. Anthony's, one young student was blown out by the reckless driving of the bike.
That is-
Those information we obtain also. We'll bring on record.
So, Mr. Manta, you're not in favor of flyovers?
At the time.
Your view has changed now.
No, but that one flyover is still there, the Jalpur they are making.
Flyovers doesn't solve anything. It just gets you faster from one traffic jam to another. Anyway, take down pursuant to the order dated 18/10/2023. Latest status report has been filed by the state respondents today, 14th November 2023. A copy of the same has also been made over to the petitioners' counsel. This is matter. Stop. Mr. S.P. Mahantana, senior counsel, on behalf of respondent number 16 has also referred to an order dated 15/11/2019 passed in PIL number 30/2019 on same subject matter. A copy whereof has been supplied to the court. The same taken on board and made part of the record. Stop. Next paragraph. Mr. H.L. Chareso has further submitted that the what is it called?
My lord, Shillong Decongestion Committee.
Shillong Decongestion Committee that has been constituted by the state respondents. Respondent does not have any independent member. Independent member.
It says others also, but the details are not here, Lord. So, the Lordship may have to
Okay, that's score it down. Mr. H.L. also prays that he may allowed to file a short affidavit to the status report filed today. So, this is a matter on Monday for the orders. Yes. Yes.
Item number 2.
Not the details have to come.
May we please your lordship, and this item require further.
There will at the request of the council party, this is a matter after 2 weeks. 2 weeks.
Deeply abreast.
I still have some ocular limitations. That's right. That's what about that other matter?
Abreast.
Item number 1.
Challenge reject.
Please, Your Lordship. Your Lordship, we have already filed a reply, Your Lordship, to the supplementary affidavit filed by the respondent
Reply?
number 2, 3 and 4, Your Lordship. The reply...
Filed a rejoinder, we have
You are
received
appearing for whom, Mr. Jindal?
district council.
You are appearing to the council. And then MS Pony? Together with Mr. Jindal? No, for the council.
For the council, I'm with them.
Yes, he is.
We're assisting.
Okay, yes. What do you want today?
It may be posted for hearing, Your Lordship.
They have filed a rejoinder to our
Rejoinder.
affidavit.
Yes, Your Lordship.
We have received the copy recently. We need some time to go through.
When did you
The
file
matter
it?
come after 3 weeks.
When did
It
you
was
file it?
filed on 3rd November, Your Lordship, 2023.
3rd November. Mr.
Actually, it has not come to me. It is still
Another senior counsel appearing for the respondent number 1,
2 and 3.
2 and 3. State respondents. You're appearing for the state or council?
District council.
For the respondent council 2 and 3. Submits that they have just received a copy of the rejoinder and require some time to go through the same. This is matter after 2 weeks. Also, yes.
Hello.
What are you challenging?
We're challenging the regulation, Your Lordship, called the Garo Hills Autonomous District Council.
The one
Land
passed in
Boundary, Your
54.
Lordship. 1954, Your Lordship.
Okay.
Item number 2.
Highly obliged.
Lordship, this is an analogous matter, Lordship, to the item 1. So in this matter, Lordship, we haven't filed our affidavit, Lordship, and we require some time to obtain instruction, Lordship. So, sometime it.
This is matter together with so and so. In the meanwhile, affidavit to be filed.
Rejoinder, not affidavit.
Rejoinder affidavit to be filed by the petitioner.
Obliged, Lordship.
Item number 3.
No, it's fine. You don't like e-filling code? I don't like e-filling code. Band karo.
Item 3.
You how much play fan? The same.
Different regulation, my lord.
Different regulation, Your Lordship.
Here we are yet to file our affidavits, Lordship. I'm praying for further 3 weeks' time to file our affidavit.
It's a fresh matter.
Fresh matter, my lord.
Yes, Mr. SD, there are council 2, 3 and 4. Oh, Mr. S. Deb, sorry. There are council 2, 3 and 4. Praise for how much time?
3 weeks, my lord.
Further 3 weeks time to file affidavit. So praise allowed this after 3 weeks.
State in this matter, respond number 1. I may also be granted 3 weeks.
Yes, similar pray made on behalf of the respond number 1. Accordingly granted this. That's it. So immediately you come back to single bench.
Any mention?
Yes.
Kumar.
Yes.
My Lord, I beg to mention hearing number 27. In fact, my Lord, I have some personal difficulties today. Unable to stand long. So may I pray for 2 weeks, my Lord.
This series of matters
Series of
will not be possible today for me also.
My Lord.
Yes, 27 to
30, Your Lordship.
to
30, Your Lordship.
30, my Lord.
30, yes. Due to personal difficulty of the senior arguing counsel, this is matter on.
After 2 weeks, my Lord, if Lordship permits.
Okay. After 2 weeks, yes.
Highly obliged.
Obliged, Lordship.
Yes. Yes. Right.
Should I beg to mention item 39, my lord?
39 years.
I'm praying for some accommodation, my lord, too.
2 weeks, yes. On the request, no objection.
No objection,
Request
Lordship.
of the counsel of the petitioner, yes.
Obliged, Lordship.
Yes.
May it please your Lordship, I beg to mention item number 41.
30?
41.
41.
3 weeks' time may be allowed.
You're for the respondent.
And for the respondents, 3, 4, and 5.
No objection.
No objection, Lord.
2 weeks.
3 weeks' time, your Lordship.
2 weeks, yes.
Obliged, Lord.
Yes.
May I please, Your Lordship, I beg to mention item number 40, Your Lordship. Let this matter be taken after 2 weeks.
40.
Yes, Your Lordship.
Okay, yes.
May I please, Your Lordship?
Yes, Mr. Yes.
My lord, I beg to mention item number 35 and 36, my lord.
Yes.
Similar matter is pending before the Honorable Supreme Court, my lord.
Yes. Okay, as the counsel with the petition submits that as similar matters are pending before the Honorable Supreme Court, the matter be listed after 3 weeks. Yes.
My lord.
Much obliged.
4 weeks, okay. Yes. Yes, after 4 weeks, yes. Yes.
May it please your Lordship. Your Lordship, I beg to mention item number 38, Your Lordship. I pray that the matter may come up after 3 weeks, Your Lordship.
No, 3 weeks, 2 weeks, yes, 22 matter, yes.
Objections.
Highly
2 weeks,
obliged.
yes.
Lord, I beg to
Pension
mention-
matter?
It's for the regularization, Your Lordship.
Okay, yes.
My Lord, I beg to mention item number 32. My Lord, I pray for some more time.
32?
The consent of the 32.
Some more time for what?
For preparations.
1 week. After 1 week, yes.
Much more.
Yes.
Lordship, I beg to mention item number 42, my lord.
You have not filed a post-mortem report?
We have already filed yesterday, ma'am.
Yes, who's appearing on the other side? What do you want to? What do you want today?
Kindly adjourn matter for today, ma'am.
After 2 weeks.
2 weeks.
Okay, 2 weeks. Yes. The request comes from petitioner. Yes. Mr. 34.
Mention item 34. Conducting counsel unavailable.
She's not well.
Not well.
She's for respondent number. Okay, for what number? 5. The conducting counsel for number 5 is still to be unwell. This is matter after
2 weeks.
2 weeks.
Yes, Lord.
Okay, that's.
Oh,
yes.
Obliged, Your Lordship.
31. Yes.
Supplementary list, item number 1.
Yes, number 1.
Lordship, I'm praying that this matter may come up at the end of the vote, Your Lordship.
Another vote will come after 5 minutes.
Your Lordship.
Where's Mr. Paul?
He's on his way, Your Lordship.
Is in Shillong?
Your Lordship.
After some time, yes.
Any obliged.
Item number 2.
Lordship directed us to obtain instructions in this matter with regard to the payment.
Yes.
Yesterday we received a communication from Power Grid.
What does it say, Mr. Sen?
about 69 lakhs has been deposited into our account for disbursement.
Then what has happened to that amount?
Hello?
What has happened to the amount?
80% of the compensation.
No, now they're saying that construction has started or something without the.
Without
what was submission, sorry?
Lordship, till now also they have never received the NOC from us. Neither have they executed agreement with us, or neither they even never came forward to survey the land. The norms were never followed, Lordship. The first instance.
This amount is for payment to the petitioner.
This was the amount was never told to us. They never came forward how much they are taking. They never evaluated.
Now have you given a copy to her?
Oh, I'll just give it.
What should we do this matter? 69 lakhs. How large is the area?
So kindly just see the writ petition for a moment. Their prayer is twofold. One is that they be paid compensation under the 2013 Act, and the other, which is in the alternate, that they be given jobs as per the scheme of 2017. Either prayer can be granted, both cannot be granted together.
1 second.
So Lordships are aware, as far as the 2017 scheme is concerned, the transfer of the land or the donation of the land must be evidenced by a registered document.
And donation must be without any consideration.
Lordship.
But Lordship, how do we give it that we have never executed, Lordship? We said that also in the minutes of the
direct the
meeting.
response to compensate the petitioner for the land acquired by the respondents as per the provisions of right. So you've been given this amount. How is the assessment done?
So that I'll have to take instructions.
Lordship.
Yes, Mr. Kera.
Lordship, they are claiming compensation under the 2013 Act.
Correct.
Whereas 2013 Act is not applicable to us. The schedule to section 105 very clearly defines.
On what basis assessment done that you arrived at the amount of
Lordship.
69 lakhs?
Lordship, this is the preliminary assessment which has been done. That is why we have fixed it at 80% of the amount. Once the work is completed, we will be assessing the final damage. Now, Lordship, the compensatory assessment is done on the basis of surface damage tree crop compensation in view of section 10 of the Telegraph Act, the powers of which we inherit by virtue of 164 of the Electricity Act.
Okay.
The second part of the compensation is, Lordship, that we pay 15% of the value fixed by the government authorities, state authorities, for the right of way, that is the corridor of stringing, and 80% of the diminishing value of the land, again as fixed by the state authorities for the tower base area.
Understood. The thing is that now you've received a copy of this one, pursuant to the order dated 13/11/2023. The senior government advocate has produced communication dated 13/11/2023 itself, showing that an amount of rupees 69 lakhs 5,896 has been deposited by the respondent number 3 in the account of the district collector, Dibhoi district.
Lordship.
Dibhoi district.
Lordship, we did this on the 25th of August. We have already filed our affidavit and we have brought this on record on an earlier occasion also.
Yes, no, because he said he was ignorant about the fact of whether any money was lying with the collector. That is why matters listed today. A copy of the said communication has been made over to the counsel of the petitioner, who is to receive. You want to take some instructions?
Yes, Lordship.
Yes, who please allowed to receive instructions from the petitioner. This is matter up to 1 week. Copy of the letter dated 13/11/2023 is taken on board with part of the record.
I want to file my affidavit also to their reply, Lordship, the power grid, which they are saying they are relying on the Telegraph Act and all that also. There are.
You have filed affidavit?
No, I have not, Lordship. I'll be filing a reply to that.
Further prayers made to allow the petition to file, rejoin the affidavit files for number 3. Prayers allowed this list accordingly. List after 2 weeks.
Obliged.
Highly obliged, Lordship.
Lordship, there is one development in this matter. We have finished the construction of the
That
tower
doesn't
as well
matter.
as stringing.
That's whatever consequential things are there, that the law will take its own course. Yeah.
Main list, item number 1.
My lord, I may seek some accommodation, my lord, after 2 weeks.
Why are you seeking? It's been listed for adoption hearing for n number of times now.
They have some personal difficulties. I cannot stand down. I have some problem. So only
My lord,
a week's time may be given also.
the annexures 6 in the writ petition which was, they said they have English translations, but I don't think there is an English translation to that, my lord.
It is there.
Because it is
It is there. We found earlier, I skipped, my lord.
Yeah, Mr. H.S. Sangre so praised that he allowed some accommodation due to extreme personal difficulty. Prayers are list after
2 weeks.
2 weeks. Yeah, 2 weeks. Take 3 weeks. It comes in before Christmas. Just after 3 weeks. Yeah.
Item number 2.
Well, it's item number 2 is that review petition, Millets, where your lordships
Yeah.
on the last occasion had directed the matter for listing today for admission hearing.
Yeah.
Well, I was only praying if your lordships could kindly allow us a day's time, Millets. 2 judgments that I'm relying on, Millets, I wanted to just place it before your lordships. We've unfortunately not carried it today.
Yeah, I hope I get my glasses also in 1 day's time. Yes, list this matter after 1 week. Yes.
After.
And the prayer of the General Council for the review petitioner.
Item number 3.
Yes. What is for today, Mr. Jindal?
Lordship, this particular item can be disposed of today in view of developments that have occurred in item number 9, my lord. If Lordship would kindly, Lordship, this particular matter we had filed against an order passed by MACT Shillong, whereby orders
contempt.
No, so item number 9, my lord, is the contempt.
9 is the contempt
of today's list, my lord, of my lord's list. So 9 is the contempt matter,
right?
And this matter, number 3, is a petition we had filed, a revision petition. If I can just explain what has happened, my lord, if Lordship would look at number 9.
Number 9.
Lordship, number 9 is a contempt filed by my friend. Contempt arises from an award passed by MACT Shillong. Against that award, my lord, award was passed in 3 cases, analogous cases. Against that award, we filed an appeal before Honorable High Court. Honorable High Court, my lord, dismissed our appeal. Against that dismissal, my lord, we were in the process of taking a decision as to whether to approach the Supreme Court, my lord. That process, my lord, took some time. That process took time. In view of the non-compliance of the award, my friend has filed this contempt petition, my lord. In the meantime, my lord, what has happened is view has been taken that it will be fruitless to approach the Supreme Court. So approval has come through yesterday. But today, through the course of the day, we'll make the required payments, my lord, through NEFT. So contempt can also be disposed of, or it can come up after a week for report.
After a week, do you have to comply with whatever?
Yes,
order is there?
yes, my lord. Yes, my lord. So today, by end of day, my lord, we should have complied. In the meantime, my lord, number 3 is a petition, is a revision we had filed against an order passed by MACT Shillong on a substitution petition. Out of those 3 cases, one claimant had died, substitution was filed. In a substitution petition, MACT Shillong asked us to give an explanation as to non-compliance of the award, essentially initiating an execution.
Who was the person who's the deceased person from among these 3?
From amongst 3, my lord, in MSC case number 95. That would be appeal number 2. Appeal number 3, I think.
No, is it Shimir Milimgap, Meris Khalmalki or?
Meris Khalmalki. Meris Khalmalki.
Okay.
So number 3.
No quarrel with that.
No. So number 3, my lord, since we had come against an order where MCT wanted to enforce the award in a substitution petition, in view of the fact.
Dispose it off, Mr. You shouldn't have any objection.
Against number 3 can be disposed. Number 9,
we'll hold it till.
We'll file a report.
1 week, yes. It has been
submitted. Lordship, your lordship. One thing regarding the item number 3.
Yes.
Revision petition which they have filed. I have nothing, of course, I can pursue with my substitution petition, which is pending for disposal. But my humble submission remains that till now, until I file the contempt petition, even they have not complied with the High Court's order. And whatever may be the case, even in regards to this, I have nothing regarding the revision petition. But the fact is that they could have already paid at least the other two, which was already since
No, but now
many
they're in
months
the
past.
process of complying. So let us see if they don't within 1 week's time, then the orders will follow.
Yes, Lordship. And even as far as merits is concerned, Lordship, they should.
No, we'll not go to merits at all because see, the Learned Council has submitted at the bar that these are developments and then like they're not pursuing the appeals. So they're going to comply with the order in the course of the day itself.
Yes.
Okay. Yes. So now if they don't comply, then orders will follow. We'll ask the concerned person to appear personally also if necessary. Mr. S. Jindal, item number 3, submits that what was his submission? With
my
the
lord, as far
decision
as
taken by the petitioner
Yes,
with regard to other connected matters as to compliance of the orders of the tribunal and of this court. The petitioner will make the necessary payments in the course of the day, right?
Yes, ma'am.
In the course of the day. Stop. With regard to incident matter, the substitution is still pending.
Yes, my lord.
Or has it been completed?
My lord, this particular number 3, we had come against a particular order.
No, right. But then you have nothing, no quarrel against substitution.
No, my lord, because the order has to go, because the order directed us to give an explanation in a substitution petition. So if the order goes, substitution will remain. So MACT will deal with the substitution.
So, you understand that?
I got it, Lordship, but their payment as far as the deceased mother is concerned, they should be making the payment because as far as
of course they make the payment.
Then after the substitution allowed, then only they have any right to object. They can object.
We are making the payment into the account of the court, of the court of MACT, so they can withdraw as and when substitution is done.
That is allowed. I have no objection.
Petitioner will make necessary payment in the course of the day. As it was always stated, the decision was taken by the commissioner with regard to
by the commissioner.
Decision taken by the commissioner.
But
I didn't say that. With regard, Mr. Isra submits that what was this for pool area?
So I just always said the decision taken by
the petitioner company with regard to other connected matters in compliance to the orders of the tribunal and of this court. The required payments will be made in the course of the day. Stop. In the present application, whereby the petitioner company has assailed the order of the tribunal itself, right?
Yes.
Of the tribunal, wherein in a substitution application orders have been passed for compliance. He submits that the amount due, the awarded amount shall be deposited into the account of the tribunal to await the outcome of the substitution application pending therein. Stop. Mr. Rakesh Singh, appearing on behalf of the respondent, has vehemently submitted that the petitioner company till date has not complied with the orders and the amounts due and the awarded amounts are yet to be paid to the respondents, what do we call them?
Claimants.
To the claimants, right? Which had occasioned the filing of, that is, what is the matter? Contempt application number
29 of 2023.
29
2023,
which is listed at item number 9 today. So, he therefore prays that he therefore submits that if the orders are complied with expeditiously, then the entire matter can be closed. Next paragraph. Having heard and counsel of the parties and on the submissions of Ms. S. General at the bar that due compliance will be carried out as per the orders of the tribunal and of this court. In the instant petition, nothing remains for further consideration, and such the same is closed. So, in para number 9 and item number 9, list this matter after 1 week for further orders.
Item number 4.
Come here, offence. Come here, he turned Malay.
My lord, conducting counsel, Mr. Daniel Khan, he just had an operation, my lord, so he cannot travel. If this matter can be listed after 3 weeks.
No, see where's the last? I think I remember the matter correctly. What is the status, Dr. Mojika?
Pending before government.
Has the plot been handed over to state government?
It's pending for execution of lease agreement, if I am not wrong, my lord.
No, not lease agreement there. What about the plot
The
where
state government is supposed
what
to
about this? What is that? The petrol pump where situated now. Have you handed over to state government?
No, my lord.
Why?
But the petrol pump is still running. They have approached the state government to hand over us another plot of land, my lord. It appears that in principle that has been agreed to.
Yes, and
but lease agreement has not been signed to them.
if I am not wrong, my lord.
So once the new site is given to them, my lord.
Only one thing here. Now, will the state government take possession of this little pump from the DESI or from the defense authorities?
My lord, state government has to deal with the defense authorities separately, my lord.
Is that happening?
As of now, my lord, we only had those preliminary instructions whereby that plot was identified.
No, that plot identified is different. We're talking about this pump, because if this is not resolved between the defense and the state and the retail, I mean whatever the petitioner.
My lord, that it appears will be resolved, my lord. Because what happened, my lord, ultimately once they vacate the land, my lord, there, that will be used for the purpose.
But is that part of the flyover?
My lord.
What part of DPR?
My lord, there is a proposal now to take the flyover up to Barik Point, my lord.
Right from
Jhalupada.
From?
Railbong Point.
Railbong, no.
That Mahavir Park, Jhalupada.
Jhalupada.
That
Jhalupada Junction, basically.
Okay.
From there, the flyover will
where
come.
the heritage museum is there.
Yes.
So from there, they'll take it to Barik Point.
Up to Barik Point. Earlier, the proposal was up to this petrol, just before this petrol pump, my lord. Now there's a proposal to take it further up to Barik Point. Take a right turn and take it up to Barik Point.
So why has the lease not been executed as yet?
My lord, I'll have to seek instructions on that, lordship.
But LAM's been identified, everything is, because that is the submission last time.
That was my preliminary instruction, lordship, and accordingly I've relayed the same to this honorable court.
Land has been identified somewhere in Upper Shillong, near that cafe, ML05.
It is just pending for execution of that lease agreement, my lord, if I am not wrong. That is my instruction.
Where's the last order?
14/9, my lord.
Yes.
4th September.
No, Urban Affairs has not been handed over the plot of land from the veterinary. No idea.
Lordship, allow me to seek instructions, lordship, because this is
you're asking for time. No, see, your last order says that these are your instructions, that to maintain proper sanitation. Finally, a plot of land measuring so and so was identified at IDP campus, Upper Shillong, and measured as per map enclosed, which may be handed over to Urban Affairs Department. Yes, what do you want today?
My lord, I pray for 3 weeks time, my lord.
Let's hope 3 weeks time is finished. Then it can go for a decongestion committee. Yes, Mr. N. Simkan. submits that the conducting counsel, Mr. D. Khan, is indisposed and pays some accommodation of this matter for 3 weeks. This is in public interest, you know?
Yes, yes. Obliged.
Item number 5.
May I please, Your Lordship?
Yes.
Lordship, I humbly pray for 2 weeks' time to file our rejoinder.
How many times you sought to file agenda?
This is the 3rd time, Your Lordship.
The 3rd and final time.
Your Lordship.
Yes, Mrs. Rahman prays for allowed further 2 weeks time to file agenda. List thereafter answer.
5 and 6 connected, Your Lordship.
7.
Your Lordship.
Excuse me, my lord.
You file application?
My lord, I beg leave from the court to withdraw.
Why?
Withdraw from the case of this case as the counsel for the respondents.
Why?
They have disengaged, my lord.
They're not agreeable to you.
I did not question them.
Okay. So what do you want today then?
Notice may be issued.
There's no other counsel appearing. You have not engaged anybody else.
They are with me, however, we are with.
No, they have not engaged anyone. Presently today, they have not engaged anyone. You are the only counsel appearing as of
Yes,
today.
my lord, I am the only counsel. The notice may be issued to them, my lord.
Mrs. H. Molong, learned counsel for the respondent.
Number
submits
1 and 2.
that, huh?
Number 1 and 2, both.
Number 1 and 2. For the respondents 1 and 2 submits that they have been disengaged by the said respondents and prays that they be allowed to withdraw and the names be struck off from the array of counsels. Stop. It is noted that there is no replacement counsel as yet who has entered appearance on behalf of number 1 pursuant to the development as submitted by Mr. Sage Molong. In that view, next paragraph, in that view of the matter, let notice issue to the respondents 1 and 2. Let notice issue a copy of the order, sorry. In that view, the matter copy of the order be transmitted to the respondents 1 and 2. Stop. Interim order.
Yes,
the interim order shall continue until the next date. Just after receipt of report of service on the said respondents. Yes.
Item number 8.
Lordship, I am a parent for the respondent.
Yeah.
We have filed a 7-11 application and we are yet to receive the reply to that application. And it's been, Your Lordship, about 3 months.
7-11 on what ground?
Your Lordship, on the ground of it being not in compliance with section 81.
On presentation?
Presentation, limitation, and copies not being true copies.
Yes, MS Suna.
Yes, Your Lordship, we have filed our show
Today
cause
itself.
reply. Yes, Your Lordship.
You file it today.
Yes.
You receive a copy.
Yes,
Yes, sir.
we have served a copy.
A copy to the objection to the. These are 2 copies here.
Yes, Your Lordship.
Objections to the application under section order 7 rule 11 CPC has been filed today by the election petitioner, and the same is taken on board. Sublist the matter. When do you want it?
May permit me to file a rejoinder, short rejoinder to that.
Rejoinder to rejoinder. Yes, Mr. Pandey prays that he may be allowed to file a short rejoinder if so advised. When do you want to be listed? List the matter.
May come up after 3 weeks, Your Lordship.
After 3 weeks, why?
The conducting counsel is.
Election petitions have, anyway, list the matter for 3 weeks.
Obliged, Your Lordship.
Item number 10.
Ram appearing for the respondent number 11. I'm not filing affidavit in this matter.
Very good. What about 1, 2, 3?
Yes, sir, you already filed.
What about 4 to 8?
Well, it's 4 to 8. The Lordships have given us
ample time.
Well, I was just praying if your Lordships kindly have this matter next week, Malaj. I'll ensure that the affidavit is on record. It's a little tricky matter, Malaj. That's why I'm a little stuck.
You have any objection?
Lordship, similar prayer for number 9, my lord.
What is the matter about?
Pertains to the appointment of the respondent number 9, my lords, in Shillong College.
Okay. Yes, Mr. K. Paul, please. Learned Senior Counsel appearing for respondents 4 to 8 and Mr. S. Jindal for 9. Pray that we allow 1 week's time to file their respective affidavits. Praise allowed less up to 1 week.
2 weeks, my lord, if that is possible.
Stretching it, yes. Anyway, 2 weeks, okay.
11.
Your Lordship, we have filed our power today for respondent number 8. Your Lordship.
Very good. So what do you want? You want to file your affidavit or
Yes,
no?
Your Lordship. Time may be given, Your Lordship.
MS Suna has entered the parents today on behalf of respondent number 8 and phrase that we allowed how much time?
3 weeks time, Your Lordship.
3 weeks time to file affidavit. What about MS Andraji? You've been entered appearance since beginning of the case. Similar prayer made by MS Andraji for 1 to 7. Prayer allowed less up to 3 weeks.
It's my
Lordship. 12.
Please, Lordship.
Yes.
Lordship, I have filed the rejoinder affidavit.
You received it this morning,
Yes,
only, Your Lordship.
Mr. Ilalu.
Yes, Your Lordship.
Submits that as rejoinder has been filed accordingly. The pleadings are complete. This is a matter for hearing. Yeah. Individual court.
13. Bludgeon.
Lordship, I am required to file my rejoinder in this matter.
How many times you've taken time?
Lordship, this is only the second time, Lordship. What has happened is that the petitioner is in Calcutta receiving treatment and recently undergone a surgery, Lordship.
Okay.
And I am instructed that she'll be in Calcutta for her post-surgery follow-up. So, Lordship, I am paying for
submits that as the petitioner is indisposed, he could not file the rejoinder. He responds allowed further 4 weeks' time to file the said rejoinder. Just thereafter answer.
Hello, Lordship.
4 weeks' time she'll recover?
I think so, Lordship.
14.
Lordship, in this case, I have already drawn up the affidavit, but some annexures are not so legible, so I have asked to supply me this legible to annexures. Otherwise, everything was done, Your Lordship. So I may be given 2 weeks' time, Your Lordship.
Further 2 weeks' time as prayed. Allowed to GA for affidavit listed after answer.
15.
Hello.
Your Lordship, this is a matter where Your Lordship had, on the last date, directed the respondent number 4 to file a personal affidavit. In that case, Your Lordship, the petitioner will have to take steps to issue notice to the...
They didn't issue notice?
They haven't.
Lordship, I'll take steps, Lordship.
Yes, pursuant to the order dated 18/10/2023, wherein it was directed that respondent number 4 file a personal affidavit. It appears that the respondent number 4 has not been served personally. Stop. Petitioner to take step, raise at AD within 3 days for service of notice.
Status.
List thereafter also.
16.
May it please, Your Lordship.
Yes.
Your Lordship, the District Council are yet to file their affidavit, Your Lordship.
5 and 6 has been served.
Yes, Your Lordship. We have already filed an affidavit, Your Lordship.
You won't file affidavit?
Your Lordship, I humbly pray 2 weeks time, Your Lordship.
2 weeks further time as prayed by MS Andraji in behalf of 1, 2, 4 is allowed for filing affidavit. List after answer also.
17.
Lord, I am praying for 2 weeks' time, my Lord.
It's a fresh matter, not so fresh matter.
Fresh. My affidavit is ready, I am waiting for signature.
Ms. Arguru pays for further 2 weeks time to file affidavit. Just thereafter also.
18.
Please, Lordship. Lordship, I have filed the affidavit, Lordship, this matter.
Was it pending for the petitioner?
Yes, Your Lordship.
You received a copy?
Yes, Your Lordship.
You want to file a joint or no?
No, Your Lordship. Let it be a hearing in the next week, Your Lordship.
Mr. H. Karvi submits that the affidavit has been filed. Yeah, Mr. Malingam.
Yes, Your Lordship.
Mr. Malingam submits that no rejoinder will be filed. Accordingly, this is matter for hearing in Solicitor.
19.
Lordship, we had filed a rejoinder yesterday. The pleadings are complete, Lordship.
After 2 weeks, Your Lordship.
Sure, I'm pretty come up next week.
The pleadings complete. Well, this is a matter after 2 weeks for hearing.
Next week, Lordship.
After 3 weeks?
What? Next week, Lordship, because it concerns the interview of the assistant teacher, Lordship.
Doesn't matter, Mr. Ampere.
2 weeks.
We have some uniformity.
Lordship.
20.
Same, Your Lordship. Same.
Same.
1920.
Twenty-one.
Your Lordship, I pray for 2 weeks' time to file an affidavit.
Many respondents.
Yes, my lord.
What's the matter about?
It's in regard to the compensation under electricity.
So you're appearing for whom, Mr. Momin?
I'm paying for respondent 2, 7, 9, and 10, 30.
And Mr. Devnath was 1. MS is same.
3, 4, and 5.
Who's appearing for 6?
6 and 8. 6 and 8.
6 and 8. 12, 11 and 12. Number 13. So what do you all have you filed affidavits? Who has filed affidavits?
3, 4, 5 filed.
3, 4, and 5.
You filed right from the beginning. None of you have filed still. So you all pay cost to Mr. Nath then. I can't hear you, Ms. Goldie. So you don't have to pay cost.
New case.
Yes.
So we are still waiting for instruction. I believe my other colleagues also are waiting for instruction.
So I pray that they be allowed further 2 weeks time to file affidavits. So prayers allowed. Both the people come only. Those are paying for whom? Yes. Authorised, yes.
22.
Please, Your Lordship. Lordship, I pray for some time to file the affidavit, my lord.
Yes. How much time?
2 weeks
1
time,
week?
Lordship.
2 weeks for the time has prayed allowed for affidavits.
Much obliged, Lordship.
23.
Your Lordship, I filed my affidavit of service, Your Lordship.
But I think private respondent number 5 is yet to be.
Respondent number 5, Your Lordship, has deceased, Your Lordship. So has expired, Your Lordship. So
Expired? Then what are you going to do?
I'll be filing an application for striking off, Your Lordship. Number 5.
There is
no legal air.
No documental evidence. Documentary evidence pertaining to the expiry of the respondent number 5.
Who's number 5?
Number 5 is a driver, Your Lordship.
The driver?
Yes, Your Lordship.
What's the matter about?
This is a matter where, my lord, accident arose in South Garo Hills and claim application was filed at Tura. So eventually the MSD Tura passed an order.
Okay, yes, I remember, yes.
So
that they won't take it up.
My lord. And in this case, affidavit won't be required from the state. It is a matter of law, my lord.
Your number 4 has been served.
Number 4 has been refused, Your Lordship.
Then no.
Number 3 has been served, Your Lordship. The insurance company.
Oh. 4 refused. Number 3 is Royal Sundaram.
Yes, Your Lordship, the insurance company.
Take Ms. Arguru, Learned Government Advocate submits that no affidavit be necessary in the present petition, inasmuch as the question involved is purely a question of law. Stop. Next parameter, personality of service, that the service has been effected upon respondent number 3. Respondent number 4 has refused to accept notice, and respondent number 5 is reported to have expired. According to this matter, we'll take it up and try to disclose the next date. We just write for further orders after 2 weeks.
Repeat, please.
None appears on respondent number 3, though none has appeared on their behalf today.
Repeat, please.
Yes.
24.
This is Your Lordship.
May I
Lordship,
please
this
your-
matter, so far respondent number 1 and 4, we request some time, Your Lordship, for the feedback.
What's the matter about?
This is regarding selection, Your Lordship.
To which post?
Junior athletic coaches.
Junior
Athletic coaches.
Athletic coaches.
Yes, sir. Your Lordship.
Now who's appearing for?
I am appearing for 1 and 4, Your Lordship.
Lordship, I'm for 2 and 3. And
Two.
I'm for 6, Your Lordship. Sure, it is possible.
1 second. You're the selected candidate.
Yes.
1 and 4.
1 and 4, Steed, Your
ND
Lordship.
Shulai.
Yes, Your Lordship.
2 and 3 MSB Harunlang. What about number 5? None appears. You've served. Number 5
Yes, sir.
been
It's
served.
been served, Your Lordship.
So also for in Shulai we have the respondents, as also the others for the remaining respondents apart from 5 pray for allow 2 weeks time to file the affidavit.
My Lord, I've received incomplete briefs.
Then that you settle it with the lawyer, with the petitioner. You supply copies, supply complete.
Yes, Your
And
Lordship.
it'll work against you, yes.
24 and 25 is
Next item will be same, Your Lordship. Same order.
Okay.
Apply, Your Lordship.
Much obliged, Your Lordship.
26. 26.
What the hell is together with 2 minute transfer. Item 20 to 28.
Second call, supplementary item number 1.
Yes, Mr. Paul.
Millets, this controversy arises, Millets, with regard to the selection of these teachers.
Yeah.
Millets, originally there was an advertisement that was issued, Millets, whereby Millets, petitioners, there are 3 petitioners before Your Lordships, Millets, and other similarly situated candidates were permitted to participate in the selection process. Now, we submitted our applications, Millets. Now, there was a similar issue from Rajasthan, Millets, which was carried in appeal before the Honorable Supreme Court of India. And Millets, there were connected matters therewith, whereby this issue thereafter came for final adjudication before the Supreme Court.
No, what is the matter and issue?
Well, it's the selection process whereby these B.Ed candidates, I am a B.Ed candidate, Millets.
Okay.
I am a graduate with B.Ed. On the basis of graduate with B.Ed, Millets, I was
You're eligible for
I got an
selection.
MTED degree, Millets. And because I have graduation with B.Ed and MTED, Millets, I was permitted to participate in the selection process.
Okay.
Because that the central government had permitted. Now, this issue, Millets, was challenged before the Supreme Court in 2 batches of writ petition. One was an SLP, one was a writ petition, Millets. One, the allowing of these candidates was by the notification of 2018, Millets, was under challenge. As also the selection
Having
process.
B.Ed qualification.
Yes, Millets. As also the selection process was under challenge before the Supreme Court. Now, the Honorable Supreme Court, what it does is, Millets, while saving the selection process of Rajasthan, it came to a conclusion, Millets, that the power exercised by the central government in issuing the 2018 notification allowing this B.Ed candidates, Millets, was incorrect, and that notification was set aside.
So, having B.Ed candidates so cast aside, that means.
Cast aside, Millets, but it saved the selection process which was initiated prior to that date. Because it says, well, rightly or wrongly, if there is a notification, any advertisement prior to that date, Millets, that particular criteria would continue. Now, that being the position, Millets, I have my humble submission.
No, let them finish. Let them finish.
Let me finish.
Yes.
I'm sure my learned friend would have a different angle to it. Now, that being the position, Millets, the petitioners had already participated in the selection process, my lords. The advertisement was there. We had already participated in the selection process. This was prior to the judgment of the Honorable Apex Court.
Yes.
Now, a similar issue...
The selection process is over.
No, my lords, it is on.
Okay.
Now, what has happened is, why we are before your lordships is now they have come up with a list, my lords, of disqualified candidates, saying that you do not have DLED.
Okay.
So, DLED was a requirement, my lords, only if I do not have the first qualification. I'll take your lordships to the advertisement, my lords, but I'm just trying to place a brief backdrop of what has happened. Now, pursuant to the orders of the Honorable Supreme Court in the Rajasthan matter, my lords, a writ petition was filed before the Chhattisgarh High Court on similar issues. Again, my lords, where B.Ed candidates were permitted to participate in the selection process. So there was a prayer made before the Honorable Chhattisgarh High Court saying that since the Supreme Court's order has come on this issue and the 2018 notification has been set aside, the selection process must come to a standstill. These people cannot be permitted to participate. Some orders were passed therein. That gets carried in appeal again before the Honorable Supreme Court, my lords. The Honorable Supreme Court thereafter then passes an order saying that the issue of from which date would be the cutoff date for allowing these people to participate or not allowing these people to participate would be an issue to be decided by the High Court. Selection process cannot be stopped. Petitioners are permitted to participate in the selection process.
Okay.
So that is the position, my lords. I'll take your lordships through the relevant annexes. My lords, I will first take your lordships to the advertisement.
Yes.
Your lordships would find it at page 32, my lords. This is dated 14/6/23.
Yes.
Your lordships have it, my lords.
Yeah.
My lords, your lordships will see para 3 qualifications.
Yes.
It says essential qualification for lower primary school teachers, class 12 passed with 50% for general candidates and 45% for ST/SC candidates with DLED. Now, thereafter your lordships will see there is a stroke and or graduate with B.Ed as per NCTA notification dated so-and-so 2010. Now, the second qualification is, my lords, MTET pass certificate compulsory. And number third is DLED pass certificate compulsory.
Yeah.
Now the issue is, my lords, my humble understanding would be, my lords, that in para 1 where they say essential qualification would be, my lords, if I am class 10 passed with 50%
Yes.
with DLED. So first part of para 1, my lords, would have to be read with 3.
Okay.
Because DLED becomes compulsory, my lords, if I have only, I am class 12 passed with 50%.
Okay. Yes.
Now, or is the second
If you
criteria,
have
my
a
lords, which is
B.Ed,
graduate
that
with
means,
B.Ed.
Okay.
Now, on the basis
Now,
of
what's this as per NCTE?
well, that was the original notification of 2010, which came to be superseded by the subsequent notification of 2018.
Okay.
That also we have annexed, my lords. I'll take your lordships to that particular annex. Your lordships, I'll take your lordships to the annexure, to the notification. Your lordships would find it at page. No. Where is the notification?
22.
Well, it's at page 22, annexure 2, if your lordships can have it. This is the notification of 2018.
1 second.
My lords have it.
1 second. Okay, page 22.
Page 22.
Right.
Now, may I just read it? In exercise of the powers conferred under subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009 and in pursuance of the notification number so-and-so dated 31st of March 2010. Well, this is that notification that they're talking about.
Yes.
Issued by the Department of School Education and Literacy, Ministry of Human Resource Development, Government of India and the National Council for Teacher Education hereby makes the following further amendments to the notification number so-and-so dated 23rd August 2010, published in the Gazette of India Extraordinary, section 4, dated 25th of August 2010, hereinafter referred to as the said notification, namely, in the said notification, in para 1, in subpara 1, in clause A, after the words and brackets graduation and 2-year diploma in elementary education by whatever name known, the following shall be inserted, namely, or graduation with at least 50% marks and Bachelor of Education. My lord, so it is graduation with B.Ed.
Okay. Not class 12 anymore.
My lord. That is in addition to 12. My lords.
Okay.
In the said notification in para 3 for subpara A, the following subpara shall be inserted. Who has acquired the qualification of Bachelor of Education from any NCT recognized institution shall be considered for appointment as a teacher in class 1 to 5, provided that the persons who are appointed as teacher shall mandatorily undergo a 6 months bridge course for elementary education recognized by NCT within 2 years of such appointment as primary teacher.
Okay. Yes. Yes.
So, your lordships, the note is important, my lords, what the query had fallen. The principal notification was published in the Gazette, my lords, dated 23rd August 2010. So, the original notification, my lords, as is
modified to this extent.
Lordships.
So, it says, we have Bachelor of Education and the set was on so or graduation 50% marks.
What was inserted is graduation with 50% marks with
yes.
B.Ed.
Right.
So, graduation with B.Ed, my lords. The source for graduation with B.Ed is from here.
Yes, okay. Right.
Now, what happened is, my lords, this issue came up before the Honorable Supreme Court. Your lordships would find it in Annexure 6, page 41.
Yes.
My lords, I'll just very quickly read paragraph 2, 3 and 4, my lords. So, your lordships will understand what is the controversy before the Supreme Court, and I'll take your lordships to what is the finding.
Page 5 also, that will also help us.
Para 5 also. Very well. We'll read para 5 as well. May I read from page 43, minutes?
Yes.
A division bench of the Rajasthan High Court dated so-and-so is under challenge before this court. Apart from these appeals, there are 3 writ petitions as well before this court on the same issues. All the same, while dealing with these cases for facts, we would be referring to civil appeal number so-and-so, Devesh Sharma versus Union of India, which arises out of an order dated so-and-so passed by the High Court in DB civil writ petition number so-and-so. What lies at the core of the dispute before this court is the notification dated 28/6/2018. This is the notification I had read before your lordship. Right. Issued by the NCTE, National Council for Teachers Education, made in exercise of its powers under 23(1) of the RTE Act 2009. This notification made B.Ed degree holders eligible for appointment to the post of primary school teachers. All the same, in spite of the above notification, when the Board of Secondary Education State of Rajasthan issued an advertisement dated so-and-so for Rajasthan teachers eligibility test, it excluded B.Ed degree holders from the list of eligible candidates. This action of the Rajasthan government was challenged before the High Court. The petitioner so-and-so has a B.Ed degree as per notification dated so-and-so. He was eligible like many other similar candidates. Consequently, he filed his petition before the Rajasthan High Court, praying that the advertisement dated so-and-so be quashed, and it was in violation of the notification dated 2018 issued by the NCT. Apart from the above batch of petitioners, there was another set of petitioners with their own grievance. These are the candidates who are diploma holders in elementary education, which was the only teaching qualification required for teachers at primary level. Well, it's DLED. And who are aggrieved by the inclusion of B.Ed qualified candidates. They too filed writ petitions before the Rajasthan High Court challenging the legality of the notification dated 28/6/2018. The state of Rajasthan understandably supported the second batch of candidates before the High Court as they would do before this court. Out of the 3 writ petitions before us, 2 are challenging the notification dated 2018 and subsequent notifications issued by the government of Bihar and UP respectively calling for application for eligible candidates including so-and-so, and again challenges the notification dated 2018 and SLP number so-and-so is against the interim order of the Calcutta High Court, which denied relief to the petitioners who are seeking a stay of the notification dated 28/6/2018. So this was the
paragraph 6. Is going to in para 6.
If my friend wants para 6, I will read para 6 as well. Hence, the question of law to be answered in this cases is whether NCT was right in including B.Ed qualification as an equivalent and essential qualification for appointment to the post of primary school teacher. The Rajasthan High Court in the impugned order has quashed the notification dated 2018 holding B.Ed candidates to be unqualified for the post of school teachers.
Okay, yes.
So now, Malas, the entire thing has gone in, Malas, and I'll take your lordship to the findings. Page
64. third paragraph. I will assist my friend. Para 22, at page 53 below. The history is there.
Your Lordship, please, as I can read the entire para 28 from page 63.
Yes.
We are also conscious of the fact that till the notification dated 28/6/2018, the consistent policy of NCT had been to exclude B.Ed candidates from the eligibility criteria of primary school teachers. In the 23/8/2010 notification, the first given by the NCT in its capacity as the academic authority under Section 23 of the Act of the RTE Act, which had been referred in the preceding paragraphs, B.Ed qualified teachers were not considered for primary classes. All the same, purely in order to equip the various state governments to establish enough training colleges, centers for imparting specialized training for elementary teachers, the B.Ed candidates were to continue for a very limited period. This was during the initial period starting for the year 2010 onwards, and when the Act and the subsequent order of NCT laid down the qualifications for primary school teachers throughout the country, but essentially B.Ed qualified candidates were kept out of the purview of the eligibility of teachers in the primary schools, as B.Ed was not considered a qualification for teachers at primary level. The inherent pedagogical weakness in B.Ed courses for primary classes is well recognized, and it is for this reason that the impugned notification itself, it is provided that B.Ed teachers would have to undergo a 6 months training in elementary classes within the first 2 years of the appointment. In this background, the inclusion of B.Ed candidates for primary level classes is beyond our comprehension. We have seen so far that the need for quality and meaningful primary education was emphasized by the legislature as well as by the academic authority all throughout. In primary education, any compromise on quality of education would mean going against the very mandate of Article 21A of the Constitution of the Act. The value of primary education can never be overstated. My lords, then they have. I will skip all this, my lords. May not be relevant for our purposes. I will take your lordship straight to page 83. If your lordships had page 83, my lords, the second paragraph at page 83. This is from where the findings start. Your lordships have it, my lords.
Yes.
The decision whether to include or exclude B.Ed as a qualification for teachers in primary school is an academic decision which has to be taken after proper study of the academic body, that is NCT, and should be better left to this expert body. But as we have seen, this decision to include B.Ed as a qualification is not an independent decision of NCT, but was the decision of the central government, and NCT was simply directed to carry it out, for that being a direction under Section 29 of the NCT Act, a direction NCTE followed. In the present case and the larger context of the matter, we cannot even see this as a policy decision. But without getting into this argument, even presuming for the sake of argument that the decision taken by the government level to include B.Ed as a qualification for teachers at the primary level is a policy decision, we must say that this decision is not correct, as it is contrary to the purpose of the Act. In fact, it goes against the letter and spirit of the fundamental rights enshrined in the Constitution under Article 21A. It is against the specific mandate of the Act, which calls for a free, compulsory and meaningful primary education to children. By including B.Ed as a qualification for teachers for primary school, the central government has acted against the provisions of the Constitution and laws. The only logic given by the central government to include B.Ed as a qualification is that the higher qualification. This we have already seen is not correct. Under these circumstances, we have no hesitation to say that the notification has rightly been quashed and the decision of the division bench of the Rajasthan High Court has to be upheld. In our considered opinion, therefore, the direction of the central government dated 35 to 2018, culminating into the notification of 28/6/2018 of the NCT Act, are violative of the principles laid down in the RTE Act. Not only this, the notification goes against the purpose and mandate of law, which has to provide a meaningful and quality primary education to children. The entire exercise is also procedurally flawed. The notification dated so-and-so is not independent decision taken by the NCT after due deliberation, but it simply follows the direction of the central government, a direction which fails to take into consideration the objective realities of the day. Having made the above determination, we all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling for applications from B.Ed qualified candidates. Lordships will kindly take note of this, for the reason that till the time when an advertisement was issued by the Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of NCT, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed that we are of the opinion that the state government could not have ignored the notification while inviting applications for RET, even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal. The same had to be stayed or set aside by a competent court before it could be ignored. What the Rajasthan High Court had stated in the above is the settled legal position. In a recent judgment, State of Manipur so-and-so, this position that where a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. Consequently, the appeals are dismissed and the judgment dated so-and-so by the Rajasthan High Court is upheld. The notification dated so-and-so is hereby quashed.
So this notification has been quashed. Now what happened after that?
What essentially, if I may submit, what essentially happens is the court, after scrutiny, quashes a certain notification. But as your lordships are aware,
it makes a provision that says, okay, fine, since at
whatever
the
happens prior to
time
today,
because the notification is still alive, so that means that we have to go by that.
That would be applicable. Now, that view, is further found favor with the Supreme Court again.
Yes.
Now, thereafter, I'll take your lordships. There is an application seeking modification, clarification. Nothing has happened out of that at Annexure 7. So, since it is part of the record, I had to bring it on record,
Yes.
Thereafter, your lordships, the relevant is Annexure 8. Now, this is in the High Court of Chhattisgarh, Bilaspur. If your lordships kindly have page 89.
Yes.
Your lordships have it, last paragraph of page 89, I'll just read. Learned counsel for the petitioner submits that earlier only D.Ed candidates were allowed for appointment to the post of assistant teachers, but by notification dated so-and-so, NCT has also included B.Ed at par with D.Ed for appointment for the post of assistant teacher, and accordingly state of Chhattisgarh has also included B.Ed. But the Honorable Supreme Court in a very recent judgment, the one that we refer to, held that only D.Ed candidates are eligible for appointment on the post of assistant teacher, but inclusion of B.Ed qualified candidate is illegal and quashed the notification dated so-and-so. And accordingly, rules of Chhattisgarh, state of Chhattisgarh regarding inclusion of B.Ed candidates has also held to be ultra vires. He therefore prayed that for staying the further recruitment process till final disposal of this writ petition in the interest of justice. State, of course, opposes it. Considering the arguments advanced by the learned counsel for the parties and also considering the law laid down by the apex court on the issue in question passed in so-and-so, decided on 11/8/23, and the further recruitment process with regard to the candidates having B.Ed qualification for the post of assistant teacher shall be kept in abeyance with immediate effect. Further, no final decision would be taken by the respondents in respect of such candidates till the next date of hearing. So this interim order was passed. Now, this came to be challenged before the Honorable Apex Court again, my lords, and your lordships will find the directions of the Honorable Apex Court at page 93. Your lordships have it, my lords.
Yes.
The second paragraph from the bottom, my lords. In the meantime, taking into consideration that the recruitment process which was in progress is now interrupted by the ad interim order dated 21/8/2023. And the aspect ultimately to be considered by the High Court is with regard to the manner in which the judgment in CA number 5068 of 23 passed by this court is to be construed. At this stage, interrupting the recruitment process would not be justified. Therefore, to the said extent, we hereby stay the order dated 21/8/23 passed by the High Court and clarify that the recruitment process which was in progress prior to the date of the said interim order passed by the High Court shall continue, and the appointments, if any, made thereunder will however remain subject to the result of the consideration to be made by the High Court in WPC number so-and-so. The selected candidates shall be informed of the same by the appointing authority concerned. In the meantime, notwithstanding the pendency of these petitions, the petitioners herein may also implead themselves before the High Court in the writ petitions, High Court deems it fit to hear the parties and consider the writ petition on its own merits in accordance with law.
Yes.
So, my lords, the view taken by the Honorable Supreme Court again in the subsequent matters is also the same, my lords. That's once the process has been initiated, irrespective of the fact that subsequently, my lords, there has been a judicial.
So what happened here in your case, yeah?
In my case, my lords, I have shown your lordships what was the advertisement.
Yeah.
We had applied, my lords. And now, at Annexure 5, page 34, my lords, there is this reject list. Well, your lordship will kindly see this is dated the 6th of November 2023.
Yes.
Date, as per letter number so and so dated 27th October 23, the following applicants, the candidates whose names are listed in the below for the post of assistant teacher in government lower so and so, falling under Ampatti subdivision of South West Garo Hills district or Meghalaya, are hereby rejected. The reasons for rejection is mentioned on the appropriate box. Any candidate of the given list may come to the office of the undersigned for necessary clarification or to claim on or before 16 November 2023, after which any claim of objection shall not be entertained. Now, my name is at serial number 88, my lords. Petitioner number 1 is at serial number 88.
Okay.
Malaj, Vicky S. Sangma Malaj, no DLEd.
Then he has any BEd.
He has BEd, graduation with BEd and MTET Malaj.
Okay. So all is rejected on no DLEd.
Yes, lordships. Basically, Malaj, what has happened is
now have you put in your applications?
Objection, Malaj.
The applications for the postal advertisement.
Yes, Malaj.
Advertisement dated 14/6. Last date for submission was?
Lordships, just bear with me for a second. Malaj, page 33. Applications should reach the office of the SDSO Ampatti on or before 31st August 2023.
So you all put in the application.
Malaj, we had applied.
And this was just dated 14/6/20.
3 Malaj.
When is the order passed with the Supreme Court?
11/8/23. That is after the advertisement, Malaj, after we had filed in our applications.
11/8.
Lordships.
Yes, Mr. Alfie General, yes. Yes. You unmute yourself, please.
Am I audible, Milord?
Yes. Yes.
So, Lordship, kindly see the first issue, Milord. First issue is that the petitioner number 2 and 3 are not competent to file the requisition. That is my preliminary objection, Milord. Because if your Lordship will see what they have done is that they have said that there is an authorization, page 21.
No, forget about the technical objections. Just come to the core issue.
I will come to the next, Milord. Yes. What my friend has said, Milord, that the Honorable Supreme Court has protected the candidates who are having BA degree in Rajasthan. Therefore, they are also protected here. Yes. If I have understood the argument correctly, Milord.
Right. Not protected. They should be given similar protection because the selection process is pursuant to advertisement dated June, correct?
June 14th.
And so and the Supreme Court set aside notification allowing them to take part.
Yes, kindly see Rajasthan judgment at page 41, Milord.
Just read it out.
Rajasthan judgment. Yes, so Lordship, kindly see Rajasthan judgment. Rajasthan judgment, Milord, the facts are like this, Milord. The Rajasthan government, without notification getting set aside, without notification being set aside, Milord, Rajasthan government excluded the BA candidate. That the BA candidate came to High Court, he challenged the exclusion. Rajasthan High Court examined the notification of 2018 and it said that BA cannot be part of primary school teacher qualification. And it set aside the notification of 2018. While setting aside the notification of 2018, it made the observation saying that government without this 2018 notification could not have excluded the BA. That is the because till when the advertisement was issued, there was no setting aside of 2018 notification. So therefore, when matter reached to the Supreme Court in plain agreement paragraph, if you will see, says that the notification is now wider in issue. That means from 2018. That part has not been read out clearly. Kindly see that part, page 41. That there we like the crux, my lord. If you also will see last case 86.
Yes.
86 minutes, what the, after 3 lines, what the Rajasthan High Court has stated about the settled legal position. In a recent 3 judgment of this court in the state of Manipur versus Suraj Kumar Okara, his position is that a statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been created. So the sum and substance is once it is declared invalid, ultra-vires, it will go back to 2018. So as of today, the consideration is taking place, my lord. This 2018 notification will not come in the rescue of the petitioner, my lord. I have got 3 judgments directly on that issue, my lord, directly on that point. If you also will see Manipur judgment which has been relied by and in that context, the BA students in Rajasthan High Court and Rajasthan have been excluded, Lord, because it has not been held as primary qualification. And for that clarity, you will also will see at page 41, page 64. Page 64 at the middle of the page of page 64. Middle one line, middle of page. In this background, the inclusion of BA candidates for primary class is beyond our comprehension. What Supreme Court says that BA cannot be included for primary school teachers. So the law declared by Supreme Court as of today is that 2018 notification is passed. It is wide of an issue and it cannot be included as primary education qualification.
No, but how do you defend your own adjustment then?
No, now you also will see that is the point which is very pertinent. You also will see this Manipur judgment which has been cited by the Honorable Supreme Court in the last paragraph. Because it's not the date of impeachment law, because it's on the date of impeachment law has not been declared as invalid. After the date of impeachment law has been declared invalid.
Exactly. So what is the fallout of that?
This effect is, if you also will see the recent Supreme Court judgment which has placed 2020. 3 SSC online 506, my colleague will hand over the judgment. 2020.
Okay, before you continue, at what stage is selection process?
The selection is at the stage of they have applied, we are applying, the consideration will take place. The law is now, law is that it's not the impeachment on the date of consideration, the whole process will be covered.
No, but when the rejection is November 4th.
Yes. And you also will see rejection is November because the law has come in between, saying that 2018 notification is invalid and we cannot rely on BA qualification. Once law has been declared and it is wide of issue, kindly give me 2 minutes, kindly see Manipur judgment, which the Honorable Supreme Court.
So the selection process already underway, so that's the only thing, it'll follow the other judgments. Yes.
I was going to say a balance in the subsequent Chhattisgarh matter.
Paragraph 22, you also kindly see paragraph 22. At page 22, paragraph 22.
Yes.
When a statute is adjudicated to be unconstitutional, it is as if it has never been, rights cannot be built upon under it. The contract which depends upon it for their consideration and why it constitutes a protection to no one who has acted under it, and no one can have punished for having refused obedience to the before decision was made. Now this is, and then you also Justice Chanchu's decision, recent decision in 2023 SSC online on 506. That 2023 SSC online 506. And the paragraph, my lord, kindly see.
Paragraph?
27. Issue number 3, my lord. Whether the post of teacher could be filled as
where are you reading?
I am reading paragraph 27 and the bold part, my lord. This is the judgment, title of the judgment, my lord.
Yes. Right.
Yes, paragraph 27, you will also see the heading of that judgment, my lord.
Yes. Whether the post teachers could be filled as.
Post of teachers could be be filled as per the rules and regulations that existed when the vacancies arose, and not as per the amended regulations.
Yes.
The division bench as well as a single judge of the High Court accepted the submission of the settled candidate that the vacancies to the post of teacher could be filled only as per rules and regulations that operated when vacancies arose, not as per regulations that came to be amended thereafter. We have already held that approval of the kindly skip that part 30. In any event, it is now a settled principle of law that a candidate has a right to be considered in the light of existing rule, which implies rule in force as on date of consideration. The principle is affirmed by this court in Deepak Agarwal. It is now by a settled provision of law that candidate has the right to be considered in the light of existing rules, which implies the rule in force on the date of consideration took place. There is no rule of universal or absolute application that vacancies are to be filled invariably by the law existing on the date when the vacancies arise. Requirement of filling up old vacancies under the old rules intervening with candidate having required right to be considered for promotion. Right to be considered for promotion accrues on the date of consideration of the election, unless of course applicable rules in YB Regalia is laid down any particular time within which selection process to begin. In the present case, consideration for promotion took place after the amendment came into operation. Thus, it cannot be accepted that any accrued or vested right of applicant has been taken away. While reaffirming the above principle, in a subsequent case of Rajasthan so and so, this court, there is a merit in this submission which has been urged on behalf of the applicant that the respondent has no vested right to promotion, but only right to be considered in accordance with the rules as they existed on date when the case for promotion was taken up. The principle has been reached in several cases.
No, but okay, fine. But the thing is that what do you mean by selection? What with advertisement doesn't mean that selection process has already been kicked off. Initiated.
Yes, your lordship, the selection process has kicked off, but consideration is taking place as of today.
Now, consideration will not advertisement, the entire process involved, be part of the entire consideration process.
No, your lordship, consideration will when I will go for appointment of the candidate, my lord, and that is if your lordship will see what has happened in Chhattisgarh also, which my friend has cited. In Chhattisgarh, my lord, the BA was included as one of the qualifications. That was stayed by the entire selection process was stayed. The Honorable Supreme Court has said that don't stay the entire selection process. In our case, my lord, facts of the fact situation in the case, my lord, can you see the advertisement? The whole line is on the advertisement. Can you see the advertisement at page 32. This advertisement law requires three things, which my friend has. One is BA pass certificate compulsory. I say so that it is compulsory certificate. And rejection is based on the ground that they are not having here. Milon, can you see the advertisement for a moment, page 34?
Yes.
32, serial number 3, Milon, because my friend has read serial number 1. Serial number 3.
No, we've seen that. He's read serial number 3 also. DLED pass certificate compulsory.
Compulsory. So this is one of the compulsory requirements and rejection order my kind.
No, how does it qualify? What about para 1, which he had submitted that you see 45% so and so or graduate would be.
The BA is, as of today, BA is no qualification since 2000 because law of Supreme Court, it is wide of an issue. Now, Supreme Court has declared that it is wide of an issue from 2018.
Very interesting point because that means the two conflicting views taken by the Supreme Court also.
No, Supreme Court has taken only one view now. There is no conflict. If you not say kindly see money.
No, while what they've done is while reserving, protecting or setting, putting that as.
No, BA candidates have not been protected in Rajasthan, my lord. That is incorrect submission. If you not even see the Rajasthan judgment, what my friend is saying, Rajasthan, they have been excluded. What has happened, my lord, Rajasthan judgment, Rajasthan government without notification being set aside, it is excluded. BA candidate went before the High Court. High Court examined the entire matter, said that BA could not have been included as primary qualification. That matter was challenged by BA candidate before Supreme Court. Supreme Court also held the view of the Rajasthan High Court on two counts. First, saying that Rajasthan government on its own should not have included because the NCT qualification is binding and mandatory on this Rajasthan. But since High Court has set aside now the B.Ed as qualification, Supreme Court has also set aside B.Ed qualification. So therefore, those B.Ed candidates are not now, in that case, B.Ed candidates are not allowed to take the part, because now that is why Manipur judgment has referred in the penultimate paragraph of the Honorable Supreme Court. Penultimate. Manipur judgment clearly says it's now one more judgment on this. Kindly see CBI versus RK Kishore on this issue, that once the Supreme Court declares the law has invalid, it is void and ineffective from beginning. Kindly see 2023 SEC online 1146.
So just one question, you answer. What stage is the selection process now?
The candidates scrutiny has been carried out. We have passed the impugn judgment. But impugn order by saying that those do not have the 95.
No, after scrutiny only. But has the selection process commenced? Have the other candidates who are eligible? I mean, as per.
No,
it is at the stage of interview.
Have they appeared for interview now?
That is why we've come before your lordships at this stage.
Can you see my impugn order? We have given them time to represent to us. That is the order which we have passed.
At 95, we went to them. They are not receiving my applications.
Can you see the rejection order? But first 95, my lord. I will just see the 95, page paragraph 95, my lord. Further, after discussing the law returned by the previous pronouncement, principal.
One second.
28 paragraph 95, my lord, of this CBI, where the law is clear.
Yes, further.
And then 28, my lord, and Roman 2 highlighted portion.
Yes.
After declaration of a statute as unconstitutional by court of law, it is non-est for all purposes.
But that's a statute.
It's not a statute. It's a
notification. Because these notifications are made under a certain provision of the RTE.
Now, your lordship if your lordship will say that no, law, the Supreme Court will declare a statute that will be non-est, but statutory notification will not be non-est. That if you also will see 95, that way if you also will see. So the purpose, and that is why the law is, if you also will see paragraph 5 of the Rajasthan judgment, writ petition was filed challenging the inclusion of B.Ed candidates. In paragraph 5 of Rajasthan judgment.
Yeah, Mr. We'll have it day after tomorrow. We'll have day after you. Can you file a short affidavit by tomorrow?
Yeah, I will file.
Well, but let it come here tomorrow, yes, sir. But Mr. Kepon is senior counsel on behalf of the petitioners. So,
I am informed that some of the interviews are scheduled for tomorrow. Lordships are having it tomorrow.
No, it doesn't matter. It doesn't matter because let me get my glasses.
Lordships, we don't want to burden the lordships.
Only thing, I'm having some problems with my close reading.
If I may only say this, my lords, what is falling from the learned advocate general, it would, even if they were to take the stand, saying that, my lords,
even then, if interviews carry on, also it's not a problem, Mr. Paul. Like in the next 2 days, the thing is that will be subject to writ petition, of course. The thing is that a very interesting point has arisen, which deserves more consideration. I feel.
Which is what I was submitting.
Let us have the objections on record.
If they say, my lords, that post my lords, my humble submission is Supreme Court never says it's void ab initio. It cannot be because it's a notification. It's just set aside.
No, fine. We're not arguing the matter any further.
Number 2, my lords, if they were to say that, they have to withdraw the notification. They have to withdraw the advertisement.
Mr. Paul, only thing is that if they have made certain very pointed objections, correct, which court also feels we need to examine further, but we need to have the objections on record.
Lordship.
Because if we have to generate some sort of judgment, we have to have it on record.
Lordship, the position of the parties would have to be crystallized.
Yes, have to be crystallized. Yes. We understand your point that you have placed reliance on the judgment of the Supreme Court, which also I feel is common sense. But then if the Advocate General says otherwise, that even notwithstanding a situation that anyway, heard Mr. K. Paul, senior counsel on behalf of the by social behalf of the petitioners. As also Mr. A. Kumar, Advocate General, appeared on behalf of all the respondents. After hearing at some length, a very pertinent points have arisen which require affidavit which requires the state response to place the objections on the interim prayer on affidavit. Yes, this is a matter day after tomorrow for admission hearing.
Day after.
Yes.
Because if they serve us a copy by tomorrow, my lords, if we are required to file
They can give it by email also.
Grateful.
He's already.
I'm sorry, my lords, we have to burden your lordships.
No, it's alright. Only that there's some issues. No, that's the only thing.
My lords, I quite appreciate.
Main list.
Yes,
Hearing item 31.
This one will take it some other day. Where's Mr. Chakravarti?
It might come up after the vacation.
After vacation, we just finished one vacation.
But we can have it in sometime in the first week of December.
Yes, this is a matter at the request of the political matter of the first week of December.
33. 33.
When?
After 2 weeks, 3 weeks.
2 weeks, my lord. That's court of inquiry, my lord.
Yes. The records have come?
Finding and the court of.
The records are required, correct?
I'll place it on the date of hearing.
Yes, parties place that matter BTM for 2 weeks. Stop. Dr. Mbozika submits that the records will be produced on the next date of hearing. Yes, also.
My lord, a copy in advance.
No.
37.
Let us court see for the records.
Definitely.
37.
After 2 weeks.
37 who for the petitioner?
My lord, and
What is the one that covers your case?
my lord.
This matter after 1 week. Yes. See, eye is a very precious thing, So like once you have some, I'm getting aberrations, so I can't really read close, like correct this. Not stress, it just impedes your function. Right. Thank you.